Yes, of course.
My lords, my lady, before the short adjournment, I took the court to Clegg. The learned judge made the point that Clegg and a number of the other cases which we cited are mining cases. True they are. The central point we make in response to that observation is that there was serious risk involved in our case as well as in the mining cases. Of course, our case is not a mining case, but we say, of course, and the judge proceeds on this basis, that it was a case where, true it may be, that at some stage it was likely that recoveries would be made for the family. But that doesn't mean it was anything like a dead cert. And more to the point, the fact that there were likely to be recoveries for the family didn't mean that we were going to make a profit, because the court will recall that there was a hurdle under the URSA of $500 million. And therefore we do respectfully take issue with the judge's approach at 454, 455 of the judgment, where the learned judge deals with this point. True it is that money was likely to come in for the family, but that doesn't take into account, as I say, the hurdle, in particular the hurdle under the URSA. And it's interesting that earlier in the judgment, if one goes back to 117, where the judge refers to the URSA, this is internal numbering, page 148, paragraph 117. The judge refers to the URSA, criticises, and on this point we do not take issue with the judge, the drafting thereof, and refers in paragraph D, 117, in what we read as, if I can put it this way, classic English understatement, as this was no mean feat. We read that as actually this was quite a bit of work. So the hurdle is therefore very relevant, and the facts actually bear it out. It wasn't until October 2016, some 5 years later, that the hurdle was, I was going to say reached, but surmounted, jumped over. So when you put those factors together, you certainly don't come to the conclusion that this was a one-way bet or anything like it. There was plainly real commercial risk, which we were taking, and therefore the mining cases are an apt analogy.
Sorry to interrupt you again. Can I just ask two things?
Yes.
Apart from the profit share that cut in above the threshold, were the defendants being paid under consultancy agreements or other arrangements?
My Lord, I don't know the precise answer to that. Can I take that question and come back to my Lord? I want to make sure we give my Lord the right answer.
Yes. The other point that was troubling me slightly is that in Clegg, one of the grounds on which the court decided that it was unconscionable was that the innocent party should have shown himself in good time willing to participate in the possible loss.
Yes.
Is that something that would have been open to the claimants in this case?
Well, I suppose it depends how the claimants fashioned their legal remedy. I mean, one thing they could have said was, they could have said, we want you to stop it. Alternatively, if you're going to do it, then you should be doing it with us. They could have done it that way. I mean, what they did was
an injunction for specific performance of a joint venture.
And I was going to come to the nature of the remedy later. I mean, clearly, being realistic, although an injunction is an available remedy in the sense that it's something you could go for, there are going to be real difficulties, I accept, with going for an injunction with cross-undertaking and mandatory injunctions, etc. I accept that. What they could have done was they could have started proceedings, and of course, I'll come to this later in more detail, but they wouldn't have been as heavy as the proceedings that in fact inured between these parties. It would have been at a much earlier stage to say, you've acted in breach of fiduciary duty, we want an account of profits of everything that you're doing, and therefore be on notice every pound you make is a pound.
That I understand. I understand you're sort of standing by.
But alternatively, allow us in. You could put that as part of your claim. Alternatively, we're willing to be partners with you in this, but you have to allow us in. That's where I was getting to with my answer to my Lord's question.
But that's a claim for an injunction, isn't it?
It's just, or,
that's a claim for a mandatory injunction.
Or it's a claim to say, if you allow, I mean, you could put it in terms, like my respectful submission, to say, if you allow us in, you wouldn't seek the relief from the court, but say, if you allow us in, we won't seek the account of profits. We're willing to share with you. We put you on notice that if you allow us in, we won't be seeking an account of profits against you. It's not something the judge can give you, but you can say to the defendant, these are the terms I'm willing to proceed on.
So it's a failure to make an offer outside proceedings or alongside proceedings to participate in the loss.
That's that point.
Is that how you put it?
My Lord, yes. But of course, we do rely on the failure to institute proceedings.
I understand that. I understand.
Yeah. I mean, what we get from Clegg is the underlying ratio of Clegg is that you can't, so to speak, wait and see. The next bit will depend on the facts of the case.
Well, that's what I'm just wondering.
Precisely.
But I'm wondering whether that is really the ratio of Clegg, because it might be said, well, what's so unconscionable about waiting and seeing? What was regarded as particularly unconscionable in that case was that the innocent party had the opportunity to bid for and take the lease themselves, and in that sense, they were therefore carefully eschewing the potential downside, which they were in a position to participate in, which is rather a little different from our case.
I accept that point's a little different, but the fundamental point, my Lord, is the same, which is that you see somebody taking a lot of risk. Your position is, if this risk turns out to work, everything you make, every last pound is going to come to me. And you don't tell them that. You just sit on your hands and you make a decision, which, and I'll have to come to this point, the judge considered was a reasonable decision. I'll come to this, to do so. That, in my respectful submission, is the underlying ratio of Clegg.
But why is that unconscionable? Can you just spell it out for me?
Because if you, the starting point is, you have remedies at law. You have remedies at law, and at law we have a policy approach that until limitation comes up, it doesn't matter how long you've waited. I mean, we all know this. There are so many cases where litigants say, oh, but they waited 5 years and 355 days or whatever to issue proceedings. And the court says, well, they're either in time or they're out of time. Here we're dealing with equitable remedy of account of profits. And the law in equity gives you a lot which the law doesn't. I mean, for example, the point that you don't have to show you could have made the profits yourself, and the other significant advantages that you get from an account of profits, which is no doubt why in many cases the claimant prefers to go for an account of profits. They may have no recoverable loss, it may be a better form of remedy. In those circumstances, equity is also saying, at the same time, it's simply not fair for you, knowing that you have this claim, knowing that the other person is taking serious risk, and of course that is built into Clegg, and we would say into this case as well, knowing this person's taking all the downside and none of the upside, it's simply not fair for you simply to sit on your hands, see which way the wind blows, and then come along and say, I'll take everything. You can do that at law. You can do that at law. But if you want to act in that way, then you'll be left to your remedies at law. The law as a whole is not denying you a remedy. You will have your contractual remedies if you've got them, for what they're worth. But if you want equitable remedies, the ratio of Clegg, and to answer my Lord's question, what I would submit is the policy underlying Clegg, is that if you want equitable remedies, you can't act in an unconscionable way. And it's simply unconscionable to sit, watch the other person taking significant risk, and then come along and say, oh, by the way, thanks very much, but I'm scooping the pool.
Is the reason that it's unfair not actually to start proceedings, because Clegg suggests it's not enough if you assert your rights, however strongly you assert them outside, is the reason that it's unfair not to start proceedings because if you had started proceedings, they would have been concluded at a time when then the defaulting party would have known what his rights were or weren't, and would no longer have then been undertaking the downside at risk, as it were. Is that the logic of it?
Well, but Lord, I would certainly accept that is certainly part of the logic of it. it doesn't appear from the reason why it's very tempting, if I may say it respectfully, just to agree. The reason why I hesitate slightly is that it doesn't appear from Clegg that the proceedings would have had to have been concluded in time, and that point would have made the difference. In other words, it was only if the proceedings would have been concluded in time that that the claimants would have been disentitled because of their failure to start.
I'm not suggesting you get that from Clegg.
Yes.
I'm trying to work out what is unfair
So
about making someone lose their right to an account of profits because they haven't commenced litigation, if I can put it in that way.
Yes.
And I'm wondering whether it's only unfair if and to the extent that had they started litigation, the defaulting party would have been in a position at an earlier stage to know that they were doing the work at risk of having to disgorge the profits. And if not, what else is unfair about it?
Well, my lord, if I can answer my lord's question this way, with my advocate's hat on, arguing this case, of course I'm tempted to agree because there's a 5-year time until the hurdle was passed, and therefore so far as money's coming in which actually inure to us, there would be time. It would, however, seem to me that the policy argument could be put at an earlier stage, because by issuing proceedings, you're saying to the party, you are absolutely on notice, not only that I'm asserting these rights, but I'm going to try and enforce these rights. And so from the moment proceedings are even issued, the other party knows, well, if I'm carrying on with this risk, I may well be doing it entirely for the benefit of my beneficiary. So while my lord's point may well be enough for me on the facts of this case, I don't want to lose my suggested explanation, which would actually take it to an earlier stage of the process for the reasons I gave.
I can understand that, because it isn't necessarily obvious that had proceedings been started at the earliest moment, which you say they should have done, that it would have made any difference to the way your clients would have behaved, or that the litigation would have been concluded before the moment at which, in fact, they performed all the recovery services and they were about to conclude a global settlement with the family. So the earlier way of putting it may not actually help you on the facts.
Well, perhaps. I mean, of course, I'm limited by the facts I've got in the judgment, and we all bring our knowledge of the speed of court process to bear on this question, and we can take a. Well,
we can just look at what's happened in this case. I mean, what I have in mind, for example, is if it did depend. Forgive me for taking you down this line, but it's troubling me, so I'd like to explore it. If it did depend on what would have happened if proceedings had been commenced, let us say, in mid-2011, which I think is about the earliest date you contend for, we know that what has in fact happened is that when proceedings were commenced in 2016, they were resisted on the basis that we've seen, on the basis that there was an entitlement to retain all the profit, and then in phase 2 resisted on the basis that there's an entitlement to retain at least 50% of the profit, and that's still what's being maintained now. And we're now not far off 6 years, or possibly more than 6 years after the litigation commenced. Now, if it were legitimate to infer that had the proceedings been commenced 5 years earlier, 5.5 years earlier, in May 2011, and that they would have taken the same course as they have in fact taken, then it may be legitimate to infer that your clients would still have performed the recovery services throughout that period in the under the contention, first of all, that they were right on liability, secondly, that even when they were wrong on liability, they were entitled to 50% or at least 25%.
My lord, of course I see that point, but I would invite my lord not to confuse apples with oranges, in the sense that the proceedings which my lord would be positing, let's say commenced in 2011, and let's say that led to a substantive hearing in 2012 or early 2013, that's at a time when the hurdle hasn't been got over. It's one thing to argue an abstract point, so to speak, as to whether you are or are not in breach of fiduciary duty because of what you've done. At that stage, of course, profits haven't been earned. So the commercial imperative on the proceedings is, I'll just put this neutrally, very different. You also wouldn't have a quantum phase, You also wouldn't have, the court would appreciate I wasn't in phase 1 or phase 2, but there was a whole issue as to other investments and how these other investments were related to the profits from here. There were a whole load of issues in both phase 1 and phase 2 which wouldn't have been there, and the scope of phase 1 would have been different. The commercial positions of the party would have been different. So although it's undoubtedly the fact that, well, we know what happened, I would respectfully say that it would be wrong to assume that we would have had the same thing, not even mutatis mutandis, if we'd started in 2011. It would be very, very different.
Thank you.
My lords, I started with... Oh, yes. Okay, Mr. Bird just reminds me to show my lords also the passage. I took my lords to 117D. There's also the point in 118 where halfway through the paragraph, the risks placed upon the defendants were extreme and indeterminate. I'm sorry for not giving the court that reference. It's paragraph 118, going to the risk involved, extreme and indeterminate. Now, I started with Claire, and we've cited some other English cases in paragraph 50 of our skeleton. I don't propose to take the court to those cases. We stand by what we've said about them, but and we say that they are helpful to us because in those cases, on those facts, time limits were imposed on accounts of profits. I acknowledge, I hope realistically, that when you look at the cases, there's a limited amount that this court is going to be able to get from them as a matter of principle. Sometimes the point came up in a discussion between the court and counsel at the end, and I can take the court to the cases, but I'm not sure it's really going to assist the court on the point. So
these are also cases dealing with intellectual property, aren't they? They don't have the same element of the fiduciary breach of duty. It's not quite the same, is it?
So some of them are. I mean, there is a statement from Lord Justice Burse in the case which I've now forgotten, but which we cite. Lifestyle, thank you. Where he says, well, you know, the rules ought to be the same.
Well, yes, he says, I think he says the rules in fiduciary duty cases should apply in intellectual
IP cases, exactly.
Necessarily the same the other way around.
No, but I mean, if the point my lady is putting to me is that there's a limited amount we can get from those cases, whether because of the point my lady has just made, or frankly because of the way the point arose, I hope realistically I'm not dissenting from that. Now, in this case, however, my learned friend, so to speak, as a result of that, seeing that I've, so to speak, got Clegg, and then these other cases, says, but if I'm right, he says, there should be loads of cases where this has occurred. I mean, it's sort of an argument from silence to an extent. The short answer to that is that I don't want to trespass back onto the dichotomy I was making on the 50-50 point, but most cases are what we were calling type 1 cases, i.e. when you've actually taken property secretly, whether it's a customer list or put your hand in the till or something like that. And those cases, for example, a secret commission, generally speaking, the claimant doesn't know what's going on while it's going on. So there's normally no question of the claimant deliberately standing by and waiting and making a conscious decision, oh, I'll just let that guy get on with it. He can take all the risk. If it turns out, I'll get all the reward. Normally the claimant's in the dark and doesn't know there's been a breach of fiduciary duty. What's unusual about this case is that the business was being carried on by us for 5 years in plain sight of Mr. Jaffrey, and yet he did nothing. So insofar as I need an answer to the evidence of absence point, that is it. Turning to the Australian cases, we refer in our skeleton to Grunt, which is another mining case, where the point is essentially the same as in Clegg. I'm not proposing to take the court to that in all submissions because we don't really get any more out of it than we get out of Clegg. And we do, however, have a more recent Australian authority in Murdoch, which I would invite the court to turn up. That's in file 4 of the authorities bundle at tab 35. And while the court is turning this up, the court will, I'm sure, have picked up, it's in paragraph 318 of the judgment, that this judgment was only given to the learned judge after closing submissions. She records that at 318, and therefore, as I'm going to submit that her reading of this case was wrong, it's only fair of me to point out that it was given to her late, and she didn't have the benefit of oral submissions on it. Yes, no, it's 35. So if we pick up Murdoch at 35, I won't take the court at this point through the head note. It's a decision of the Court of Appeal in New South Wales. If we could please turn and start at 1059, page 1059, at paragraph 183. And I'd invite the court to note paragraphs 183, 184 and 185 under the heading "Did Brian stand by?", thereby disentitling him from some of the profits. The contrast is drawn by the appellant between complete defences and those which operate only in relation to some of the profits, in the context of both standing by and also informed consent. So that's where the argument was put, that there is a complete defence, but that's not the end of it. It can also operate in relation to some of the profits. The court's consideration of this argument is over the page at paragraph 195, which is where it begins under the heading "Consideration." And in 195, the court makes the point that if there's an equitable defence, such as laches or delay, then the account of profits may be withheld entirely. That's uncontroversial. 196, secondly and separately from the above, so there's no question but that this is a different principle. The court's got power to fashion the account to achieve the purpose. And the court there refers to Warman, and Warman was where there was a defence in relation to some of the profits only, rather than a complete defence. And they say that is why in Warman, the account of profits was limited to the first 2 years of operation of the business conducted by the errant fiduciary and not 4 years.
That wasn't a justification which was regarded as acceptable, was it, by the Court of Appeal in Murad? Lord Justice Jonathan Parker, am I right in thinking,
didn't like
took the view actually that you can't justify Warman on that basis. You can justify Warman on a basis of scope of duty or extent of causation basis.
That's the way he read it in Murad.
So, if this is following that logic in Warman, it's not applying what the Court of Appeal in Murad would have thought was an appropriate route.
But we'll see, my lord, that as the court goes on, it deals with what Warman says, but applies it in a. I mean, this does go beyond Warman. This does go beyond Warman. And at 197, they refer to Warman, identifying 3 other bases on which the account could be fashioned. One is obviously the just allowance. Another is an antecedent arrangement for profit sharing. Again, it's interesting, we have the same word arrangement rather than contract. And a third was that relied on by the appellants. The conduct of the plaintiff may be such as to make it inequitable to order an account. A plaintiff may not stand by and permit the defendant to make profits and then claim entitlement to those profits. And then the discretionary defence of standing by in 198 was applied by the court in Edmonds and Donovan. And that's a decision of the Court of Appeal for the State of Victoria. So I should take the court to that. That's at tab 16 of the authorities bundle. If I can invite the court just to pick that one up.
I'm so sorry, give me the reference again.
I'm sorry, tab 16, my lord, in bundle 2 of the authorities bundle. I will be coming back to Murdoch because we're just pausing, so to speak, to pick up Edmonds. The relevant part starts on page 491 in the bundle numbering at paragraph 76. There are very small paragraph numbers on the left. And in Edmonds, the way it's put is this: as a matter of delay, there was no reason for the respondents to have waited so long before attempting to intervene in the exploitation of what they now say was stolen. Such delay smacks of their waiting to see, and then, when it proved profitable, acting opportunistically to grasp the benefit. And in 77, they refer to Reed Jarvis, which is another one of the English cases, and then quoting what we saw earlier from Lord Justice Knight Bruce in Clegg. And summing it up at the end of 77, how the matter appeared to the trial judge, I agree. There's no warrant for allowing the respondents to stand by for nearly 2 years, and then to obtain a remedy, supposing to none of this gives them all the rewards. And then the quote from Warman is simply the cardinal principle of equity, that you've got to fashion the remedy to the particular facts, which is not a particularly controversial proposition. Now, I should show the court that this case, Edmonds, if we go back to 71, was a claim for equitable compensation rather than an account. But the court held in 71 that it wouldn't have made much, if any, difference which forms of relief was claimed. They proceeded on the basis that the principles were the same. And then coming back now to paragraph 82 at page 493, I won't read it out, but the court will see that what happened there was that the court gave effect to the delay when fashioning the account by splitting it 2/6 and 4/6. So that's the interposition of Edmonds, because Murdoch at that stage of the discussion referred to Edmonds. If I could just take the court back to where we were in Murdoch, we'd looked at the section from 195 to 198. And if I could show the court 204, the court there sets out the inquiry.
Can you just give me the, I'm working on it.
Oh, I'm sorry. It's page 1062. Apologies. Paragraph 204.
I'm sorry to slow you up, but I'm just looking at paragraph 82 of Edmonds, which I haven't looked at before. And the basis of the 2/6/4/6 split was that by standing by, they'd acquiesced. That looks more like acquiescence than unconscionable delay. Where did the 2/6/4/6 come from?
That occurs. Is my lord asking why was it 2/6 and 4/6?
Yes. Well, the period we had been looking at was the 2 years in which they'd done nothing, and it's here. That's here treated as acquiescence.
Yes, because when one goes back to the facts, I lost my note of this.
Does the 2/6 correspond to the 2 years when they were sitting around?
I think that's right.
perhaps you can come back to us.
I'll come back to-
Perhaps you
yes.
can come back to us on that.
I do remember looking
because
at why it was 2.6 and 4.6, but I now can't recall. I'm sorry.
But one of the things we may have to give some
Yes.
thought to is whether standing by is really acquiescence rather than a form of unconscionable delay.
Well,
82 refers to acquiescence.
That's what caught my eye.
yes. There's going to be one would normally say though that if there's acquiescence, that would normally operate in full. It wouldn't normally operate pro tanto. I mean, acquiescence you would normally say would be a complete defence. But what we do see from Murdoch is that it certainly operates pro tanto. And then, so certainly according to normal principles, you can't use acquiescence to get to a pro tanto result. But we do have a pro tanto result. So when the court says acquiescence, do they mean acquiescence in the sense of a full acquiescence disentitling you to any remedy at all?
Well, I understand. I understand you saying whether you call it acquiescence or not, it's being applied pro tanto. But I speak for myself. I'd quite like to know on what basis.
Yeah.
And then that rather begs the question
Yeah.
as to whether there is anything different from acquiescence, even if acquiescence can operate pro tanto.
Yes.
This not being a case, i.e. our case, not being a case in which acquiescence was found.
No, I accept that. I'll come back to my lord on that. As to why it's 2.4.2.6.
Thank you. Sorry, I slowed you up.
No, not at all, man.
Where are we going next?
So I was going to go back into Murdoch because I'd shown the court Murdoch 195 to 198. And I was going to show the court Murdoch at 204, which is at page 1062 of the bundle. And that's where the court says this is the way the inquiry should be phrased. When did Brian have sufficient information for it to become inequitable thereafter for him to obtain an account for profits made while he stood by, permitting RKM and Bright Pair to continue to make those profits, bearing in mind the family and corporate history and relationship between the men? Certainly that's not put in terms of acquiescence. That's put in terms of a delay which makes it inequitable thereafter to claim all the profits. And we accept that when the question is framed in that way, the answer will depend on all the facts of the case, if I can take refuge in that phrase. The learned judge in this case, at paragraphs 301 to 302 of the judgment, said the problem with that answer is that she would have to carry out an investigation which was, quote, extraordinarily open-textured. Well, with great respect, that isn't a good reason to stand in the way of this principle. There are many cases, especially in equity, where the courts have to carry out an open-textured investigation. So we do say that Murdoch is an authority, that unconscionable delay or standing by can operate as a full defence if the facts go so far, but also a temporal limit or cut-off to the account. The claimants in this context raise another point against us, which I shall deal with now briefly, which is, even if we're right about all of this, it's too late to raise it now. We should have raised this as part of phase 1. The short answer to that is that that submission has to be wrong, because we couldn't have raised it at phase 1 because they didn't elect for an account of profits until after phase 1. We could have taken the you can't get an account at all because of delay at phase 1, But if at phase one we'd said, well, just a minute, we've got some submissions as to how the account is to be fashioned, we would have been met with the argument, well, unless you're saying we can't get an account at all, it's not for now. And that would have been right. The claimants also rely on paragraph 32 of their written case upon extracts from Snell and Spry which say that mere delay is insufficient.
Sorry to keep interrupting you. I got the impression, but I don't know enough about the procedural background, that all questions, once the election had been made, all questions as to the scope of the account were to be dealt with in phase two on the basis of, was it position papers? Was there some order for position papers to stand as pleadings?
Yes.
And did that order make clear that all matters in relation to the scope of the account were to be up for grabs in phase two?
I don't know offhand whether the order made that clear, but certainly both parties proceeded on that basis, that phase two. And the position papers were, as I've always treated them, sort of pseudo pleadings. This is what we're going to argue to give you notice of the points we're taking. And certainly no objection was taken at phase two that this point was, or the judge didn't hold at phase two, that this point was certainly out of bounds. This point was out of bounds because it should have been taken at phase one. She said that the total defence should have been taken at phase one, and with respect, she's right about that on my case. Or she could be right, it doesn't matter because we're not running the argument. But whether that was a phase one point or a phase two point, this point is certainly a phase two point. I was just making a very short submission about the extracts from Snell and Spry, which say that mere delay is insufficient. Well, of course, we're not arguing that mere delay is sufficient. It's not just the reflection of time. It's the waiting and seeing and allowing the other person, consciously allowing the other person to take the risk. Whether you
So are you saying that in any case where you find out what's going on, you need to take action very promptly?
Where you find out what... I'm sorry, I didn't mean to cut across my lady, I'm sorry.
Carry on.
I'm sorry.
I said you're saying that in any case where you found out what's going on, you have to take action pretty much straight away, or you lose your equitable relief.
If the other person is in the position of taking significant risk. Because I'm deriving this from the mining cases, and the reason why the waiting and seeing, it's the exchange I had, I think this goes back to the exchange I had with my Lord Justice Popplewell, that the reason why it's inequitable or unconscionable is not just that you've been sitting around, it's that you've been sitting around knowing that the other person is taking real risk. And that's what brings the equity in.
Can you humour me just by explaining what the risks were in this case that you say are so significant?
Well, we're having to devote huge amounts of time and therefore money to this. We have
so
at some point
money, time.
Yes, and we lent the family money at times. We were doing all.
Well, hang on. Presumably the loans were on. The repayment of the loans, is that contingent on the carry being? I mean, there's quite a lot of points you're making there.
Well, the judge, I mean, in relation to that, as I read the judgment, the judge found no risk. That was at least the solvency element. She found no risk at all on that.
Yes. The real risk here is
billions and billions and billions.
Yeah, the real risk here, standing back, is that you're doing a lot of work over a number of years in circumstances where it may well be true that money is likely to come into the family, but you may end up, because of the hurdle, doing all of that for absolutely nothing for you. That's the risk. People don't normally work for 5 or 6 years for nothing.
But that's what I'm trying to tie down. Is it the time, or are there other things? I think a question was asked earlier about consultancy fees.
Yes.
You've mentioned loans, but on the face of it, loans are normally repayable. So unless that's linked to the carrier's hurdle as well, it's not so obvious that involves.
Well, there's time, and there's also getting in the assets. That the judge explains the nature of the web of controversy about the assets. Who you're dealing with. I mean, the people you were dealing with might not be the easiest people in the world, let's put it that way. You're trying to get the assets in, and the real risk for you is that you'll expend all the money in work and paying staff and getting people in, getting the assets in. You'll end up doing it for nothing. I'm not equating it to going down the mine in the sense of physical risk, but there's a real degree of financial risk. I mean, to use the judge's phrase, she says extreme and
yes,
the
but
risk
we
of
have
extreme
to
and
also read the whole judgment, and she uses different phrases elsewhere.
She does, but one has to distinguish. If my lady's thinking, for example, of the evidence of Mr. Schvidler, one has to distinguish between getting the family ultimately getting some money in and the time and cost of getting that money in, and whether you're going to get over the hurdle to get any money for yourself. I can see from the family's position that they're sitting pretty. They know they're extremely wealthy. Sooner or later, their ship will come in. Doesn't mean that we're going to have any interest in the ship when it does.
The risk of loss for them is only loss in the sense of an opportunity cost of not spending their time earning some money elsewhere. I mean, the downside is they do an awful lot and they don't get anything. It's not a loss in the same way as an investment in a mine might be in terms of cost, but it is, you would say, at least a very significant opportunity cost.
Yes.
Of what they might otherwise be earning for 6 years.
And there are some costs involved in doing it. I mean, each case will be on its facts. I mean,
I know, but that's what we're asking you about in this
well,
case.
well, quite. But there is real risk, we say, in making in getting a return for yourself here because
there's no risk
because
in
of
the
the
sense
time
of
and the hurdle.
incurring liabilities, though, is there? There's no risk in the
Incurring
sense of
liabilities,
incurring
sorry.
liabilities.
That's unlikely to be a risk. That's unlikely to be a risk. I accept that. Yeah. That's unlikely to be a risk. Unless, of course, you started litigation to get monies in and lost it. You have to pay the cost of the litigation.
Well, we haven't got any evidence or findings of that. The litigation was on behalf of the family.
Yes, absolutely. But I'm just making the point that there are a number of different imponderables. When one assesses the question, is there risk? It's dangerous to assess it in relation to what actually happened. The test here, surely, is it's inequitable because the person who has the right is standing by while the other person is going out taking risks. Whether those risks do or do not eventuate is necessarily an impermissible part of the analysis at that stage.
Well, you can see that in many cases where you're running a business of some sort, you will be taking on risks, taking on potential liabilities. That's not this sort of case, is it? I mean, it's simply that you may be wasting your time.
Well, my lord, I certainly accept the first part of that. Wasting your time is extremely expensive. I mean, I'm not sure I'd want to do a case for 5 years.
Well, it's hard to think of any. It's hard to think of any situation where this type of claim for an account would arise, where there wouldn't be that aspect. It's hard to think of it. Hard to think of be seeking an account, and the accounting party hadn't at least been undertaking something. Yes. In the main, the sort of risks we're talking about, aren't they, are risks where somebody is going to be making commitments, financial or otherwise, which will expose them to liabilities. Well,
in a customer list case, that might or might not be the case. In a secret commission case, that might or might not be the case. There are, I would say, there are plenty of cases where the defaulting fiduciary hasn't actually taken and is not going to take significant risk. Point one. Point two, coming back to the point I made earlier, in a lot of those cases, the point won't arise because the claimant didn't know about it. And therefore, it's not unconscionable because they just didn't know.
What we're talking specifically about here is whether it's unconscionable because these claimants knew that you were taking risks.
Yes.
And what we're asking is, what did the claimant understand about what risks you were taking? And I think what we've established is that you were not potentially taking on liabilities. What you were doing was spending your time and effort on trying to recover monies for the family. So all that they knew, and I say all that they knew, not necessarily in a conclusory way, but that you might not do it if they were to commence proceedings against you?
Well, we wouldn't do it if we were told by a judge, well, I'm telling you now, it comes back to the point earlier, I'm telling you now that you can carry on doing this, but every penny you make is going to be for the claimants. I would also say that we wouldn't do it if the claimants had started proceedings and we were therefore on notice that, just a minute, we could end up in a situation where we do all of this and we keep absolutely nothing. What was going on was that we were doing all the work and the claimants were sitting on their hands. I mean, what's interesting...
Even here today, as my lord has put it, even here today now you're saying you're entitled to 50% of it.
Because of the agreement, absolutely.
And that was your position then, too?
Yes. What's interesting, though, my lord, is that so far as the judge was concerned, the judge's main objection to our delay argument wasn't that we weren't taking risk. I mean, we've seen the bits in the judgment on that, and one has to piece the pieces together. The learned judge's main objection was that Mr. Jaffe's commercial decision not to sue was a reasonable decision. And she mentions this clearly on a number of occasions. Now, as to that, and it's most clearly seen right at the end of the judgment, paragraphs 636 to 638, which are the pages 245 to 246 of the bundle. We submit we submit that to ask whether Mr. Jaffe made a commercial decision and whether it was a reasonable one is to ask the wrong question. Because put in those terms, it's always going to be commercially reasonable for a claimant to stand around and do nothing and let the other person take the risk on the basis that you might be able to scoop the pool thereafter.
What does she say commercially reasonable?
Well,
she's considering reasonable in the context of the unconscionability argument. And that must surely mean reasonable from an equitable point of view.
Well, my lord, I get that from 638. I would, in any event, the question 637 is, could he have commenced proceedings? And she essentially says, we'll come back to this, he could have commenced some form of litigation, but not this. And then in 638, had it been on the facts possible for me to conclude that it had been possible for him to commence proceedings earlier, I would in any event have concluded he essentially took a commercial and strategic decision to wait. That's why I get commercial from, my lord.
Yes. And then her conclusion is it was a reasonable one.
Well, absolutely.
What I was suggesting to you was it wasn't fair for her to characterise, or for you to characterise that as her saying, well, all that I'm deciding is that this is a commercially reasonable decision. Surely she was saying this is a reasonable decision in the context of unconscionability. I understand you say she's wrong about that, but
yes, well, I that's certainly the way I read it. But my lord, I obviously accept that she's using the word reasonable as a standalone in the pre-penultimate line.
yes.
But I do make the same point, my lord, that to ask whether it's reasonable is citing the question, so to speak, for Mr. Jaffe. But of course, it may be reasonable for him. We don't see in that paragraph, my lord, a dealing with the sitting by, the standing by, or the waiting and seeing. It may well have been in his commercial and strategic interest to do this. It may well have been reasonable for him situated where he was, given his other interests, to do it. But we're entitled, as a matter of equity, we're entitled for him to pipe up. Now, that might mean that a claimant in the position of Mr. Jaffe has to choose between his commercial and strategic interests over here and his the fact that he may lose pro tanto rights over there. But that's the way we would submit it works here.
He was acting reasonably but unconscionably.
Well, he was actually reasonably situated where he was, but unconscionably vis-a-vis against us. if Mr. Jaffe wanted only to maintain his rights at law, none of this need concern him. But we do come back to the point that if he wants his rights in equity, then we do submit that his behaviour was unconscionable, because he could, and we say should have, started some proceedings. On that really takes us to 637, where the judge finds that Mr. Jaffe would have been able to commence some form of litigation earlier than he did, but goes on to say the case that he could have afforded to commence this heavy litigation was not made out. I do invite the court, though, to note at 36.1 of my learned friend's skeleton, there is a very selective quote from that sentence, and the learned friends in their skeleton miss out the positive bit, i.e. that he could have started some form of legal action, and say that the judge concluded she tended to the view that he could not have afforded to commence this heavy litigation. Well, true, but there is a positive finding there. As to that, it takes me back to the point which I was discussing with my Lord Justice Popplewell. If he'd commenced the claim at that earlier stage, it wouldn't have been the sort of proceedings which in fact transpired. There wouldn't have been a quantum phase, we hadn't made any profits, we hadn't even yet reached an agreement with the family. Second, the judge's findings are entirely commensurate with what Mr. Jaffe was saying at the time. In our phase 2 opening at paragraph 199, this is in the supplemental bundle, tab 27, page 376. We needn't turn it up. Mr. Jaffe tells Mr. Fomichev in an email that he needs, quotes, $500,000 to start the process. He wasn't saying he needed millions to go to court, or that he couldn't go to court. What he was mulling over, as relayed to Mr. Fomichev, was whether starting legal proceedings was the commercial lever he wanted to pull at that time, and that appears from paragraph 62 of the judgment. That refers to an email where he tells Mr. Fomichev he planned to bring a claim for value in 3 years worth about 180 million. In other words, he was waiting and seeing.
So what he should have done was commence the proceedings and then sort of stay on the grounds that he didn't have the funding to go on with it.
Well, my lord, it's not clear, first of all, that he would have had the funding to go on with it, because that brings us back to this heavy litigation. The litigation would have been very different. There were many issues in the litigation which wouldn't have been apt at that stage. So there is, with respect, no basis for saying that we can proceed on the basis that he had funding to start, but the litigation would have petered out because he would have run out of money. We're dealing with a much earlier stage where the litigation would focus on, are we in breach of fiduciary duty? There wouldn't be any question of amounts, other transactions, quantum phase, anything else. So those are the submissions on whether, in principle, there should be a temporal limit on the account.
Sorry, I keep interrupting you, but there's something else that's in my mind. There is a case called Cecil and Byatt, which is about, I think, extending, whether there's good reason to extend the time for service of a writ after it's expired, in which, if I've remembered correctly, I think this court said that it wasn't a good reason that you didn't have enough money to fund the whole of the litigation. If you had enough money to start it, it's maybe a point in your favour.
Yeah.
I mentioned it now because it may be from Mr. Weisselberg. It may not be analogous. It may be. Anyway, I mention it so that you can both give that some thought and help us with it.
Grateful. And of course, what one also has to bear in mind when one is talking now about funding, this court knows that cases are funded not just by the parties. I mean, there's a market out there, and if hypothetically, and this is the basis we're going to be working on for this hypothesis, the claim is a good claim, then one also has to bring into account the question as to whether funding would be available for it. I was going to turn to the practical question as to how the account should be fashioned, which I can deal with extremely briefly. Before I do that, I've been passed a note, which, if I read it correctly, is an answer to my Lord Justice Popplewell's point, indeed the court's point, on the 2646. It appears that the 26 and 46 are the split under a 1999 profit share agreement, which arises from the head note and also paragraph 81. So let me leave, if I may, the court with that, and I'll look at it again overnight. If I need to say any more about that in reply and give the court another reference,
Head
I
note
will.
of para 91.
81, my lady. Turning therefore to my last point as to how any account should be fashioned. We accept, of course, that at this stage we really are in the court's hands as to what the court think is most appropriate. So what we've done in paragraph 60 of our skeleton is to set out various candidate dates for the cut-off. I wasn't going to go through each of them in turn in detail at this stage. Let me first deal with a preliminary point. That a point seems to be taken against me that these dates were not specifically pleaded, but they are, the concept is very clearly pleaded in our position statement, and the basis on which we were going to cross-examine Mr. Jeffrey and argue for particular dates was clear from our phase 2 skeleton. The reference for that is Supplemental Bundle, tab 27, page 377. And in our written closing, following the oral evidence, we set out our conclusions and submissions as to the dates. That's in the Supplemental Bundle, tab 33, page 521. So we've set out various candidate dates. Of course, one also has to ask the question, being realistic, because this is ultimately an equitable area. Well, how do those dates translate financially? I mean, to invite the court to pick a date when the court has no real idea how that works in pounds, shillings and pence is a little unreal. So one way to do it would be to look at what has actually been received by a particular date. That's certainly one way to do the exercise. There's an attraction in that because it's simple to apply. There's another attraction to that on this side of the court because we received all the money fairly late on. And therefore, from the point of view of my clients, that's obviously an attractive way of doing it. But
presumably after all the dates in your list.
I suspect that's probably right, in either in full or in very large part. So being realistic, and because this is a field of equity, I appreciate the court may say, well, that actually doesn't meet the justice of the case. It leads to a conclusion which, if we're applying a temporal cut-off because the claimant has acted unconscionably in failing to start proceedings, we can't have a result where nothing is received.
Well, one has to be careful to apply the unconscionability to the right concept. In Murdoch, it was carefully, and I think quite properly, applied to whether the receipt of the account of profits would be unconscionable.
Yes.
It's not simply a question of whether the delay is unconscionable.
Yes, exactly. Well, that may be another way of putting the point. You actually have to.
You have to jump. You don't just take a date at which it would not have been unconscionable to.
I don't understand, my lord, to be taking a different point to the point I'm now putting to the court. One actually has to see to make sure that the consequence on the account is an appropriate consequence, because that's what the unconscionability goes to.
Quite.
So another way, therefore, of approaching the issue would be to say this: over the entire period, we've received X dollars. The relevant delay is from the breach in May 2011 until whatever date the court thinks is the most suitable, because at that date the claimant should have started proceedings. And you say, well, we'll apply that on essentially a percentage basis to the amount which overall was obtained.
You mean just pro rata?
Pro rata. And I frankly accept that, as against me, no doubt you said, well, that's a bit rough and ready. But sometimes that's what you have to do in equity. Warman itself says at page 558, the reference is Authority Bundle 13, page 370, in the middle of the page, that what will be required on the inquiry will not be mathematical exactness, but only a reasonable approximation. And I think, if I'm remembering correctly, that's also picked up in Murdoch itself. Yes, at page, just at the court's note, at page 1061, which was the page we were looking at under the heading consideration, paragraph 199 starts, thirdly, mathematical precision in this case is illusory, and then quotes Warman and then also Mr. Justice Slade, as he then was, in My Kind of Town, as to what is required, quotes, will not be mathematical exactness, but only a reasonable approximation. So we put that before the court as another option.
Can I just see if I've understood it? Sorry if I'm being slow. So if one looks at the period over which the work was done, which produced the profit, or you look at the period over which the work was done that produced the profit, between let us say May 2011 and, I don't know, it's about late 2017, probably a bit. It'll be before the February 18 or April 18 settlement. So you've got whatever that is, 6.5 years, and then you're saying if the court came to the conclusion that proceedings ought to have been commenced, let's say a year after May 2011, then it'll be 1/6.5 of the profits that get recovered, and the rest won't. That's the sort of calculation
Essentially.
you're suggesting, right?
Can I just, getting into detail, but does it start on that approach in May 2011? Because I thought there's at least a case that a lot of work was done before that. Why are you... There's at least a case, isn't there? Now, I can't remember what the judge finds on that. There's a lot of the work that contributed to that ultimate profit was done in the period before the split.
But that's when we're in breach.
Well, yes, but you're attributing 100% of the profit to that period from May 2011. I'm not sure I follow.
Well, my lady, if my lady says, well, I see the force of the prorating, but you need to recognise that the monies weren't earned only over the 2011 to 2017 period, but actually over a longer period. Well, I mean, candidly, I see the force of that point. I do submit that our argument that you start at the breach is the better point. But if my lady is against me on that, then the answer to it would be to say, well, what you do is you say these monies were the result of work over the entire period, including the pre-breach period, and then you bring that into the equation.
Does this apply also if you're writing ground one and there was a 50-50 agreement in place?
Are they cumulative?
Yeah.
Well, I'm obviously tempted to say yes, they are cumulative, but the court is always going to have to stand back and say, because we're going to the question whether it's, if I can respectfully paraphrase what my Lord Justice Popplewell said, whether it's unconscionable to allow the claimant to have the account. Now, as a matter of logic, my argument on the first point was that my 50%, so to speak, is outside the scope of the account at all. So the logic of my position seems to me to be that I would say that they're cumulative, because what I'm saying is the account, so to speak, only ever starts to bite on the other 50%, and if they, by their sitting around and watching, have lost that, then that operates on that 50%. I mean, that does seem to be, I mean, I think that must be the logical consequence of my argument. And as a matter of pure logic, in my respectful submission, they're right. If I'm right on that first point, and I'm right on the delay point, they are independent and separate points, and they can be cumulative. Whether,
I mean, it's another aspect about this, though, isn't there? I mean, if you're right about the 50%, and that agreement remains in force and should be given effect, why isn't it also? Why doesn't it work the other way? Why is it unconscionable for them to have an account for at least 50% if that was the agreement?
Well, that is the point I was coming to, though. That the argument, if I can now argue against myself, the argument against me might be this: if what you're only ever talking about is the claimant's 50%, it's more difficult to say that sitting by and standing by and watching is unconscionable in the first place, which may be the point my lord was just putting to me.
Well, I'm not sure. Maybe a different way of putting it.
Maybe a different way of putting the same point. But I think what I understood my lord to be saying was that my winning on the 50% point, at the very least, is certainly a very relevant factor as to whether the claimant is or is not acting unconscionably when he's sitting around and waiting to see what happens on the delay point.
Well, your point, as I understand it, is that you have an agreement for 50% which survives. And you say, well, whatever we did wrong, we're entitled to 50% in equity. It's difficult to see why that doesn't, in equity, work both ways. And it's difficult to see why, if you're right about that, it would be unconscionable for the innocent party to say, well, actually, I'll have the 50% then.
That last point was the point which I was seeking to make, and I think my lord has just put it better than I did. But that very last point, in those circumstances, would be difficult to see why it's unconscionable for them to say, well, I'll have my 50%. That really was the point I was making. Absolutely.
So if you win on ground one, ground two goes away, does it?
I don't want to abandon it, my lord. If we win on ground one, I can see an argument that ground two becomes more difficult. But I'm not, with respect, I'm not willing to say that if I win on ground one, ground two must necessarily fail.
But you can see a strong argument.
I'm anything that falls from my lord is going to be a strong argument. But I certainly can see a strong argument. I certainly can see a strong argument on that. Absolutely.
Thank you.
Can I just go back to ground two on its own? There are two elements we're dealing with. One is standing by, which we have to decide the extent to which that is properly the subject matter of criticism, and find a date at which it was no longer appropriate to stand by. I put it in that way. And the second question is, to what extent is it, as a result of that, unconscionable that some element of the profits should be disgorged? Now, I would have thought one should be looking for a test that links the two. In other words, which asks, if proceedings had been commenced at the date when they ought to have been, what would the defendants have done? Is that not a necessary inquiry, rather than these just looking at the profits and picking a date? And because that would have a causative link that would link the unconscionability of disgorging of the profits to the behaviour which is being criticised and giving rise to the principle in the first place.
Well, what the defendants would have done is they would have been in a position where obviously they would have known that they were at risk, to put it at its lowest, that every pound they earn will be a pound that goes to the claimants. The defendants would also be, and this perhaps picks up the exchange we've just had, in a position where they would be saying, well, just a minute, 50% of this is ours anyway. So
well, they've been saying 100% of this is ours anyway, because that's what they said at the liability trial.
Yes.
So they've been saying that for the first half of the litigation.
Yes, but the problem with this approach is that, of course, when we say 100%, there's no 100% of anything. course, at this stage, both parties know that on the judge's findings, that it's likely that monies will come in. But it's far from clear that there's actually going to be any profit at all.
Well, I understand that, and I understand why, from where you are, you're concerned to try and get a result which gives you an answer. From where we are, we have to decide what the law is. And were we to decide that the proper approach involved some cause development, it might then be that we're not in a position to decide what that means in this case at all.
I think being fair, I don't think I can submit that on the and I'll be corrected, that on the material which the court has, the court is going to be able easily to answer that causation question. I appreciate I have a short reply tomorrow, and I don't propose in a reply to repeat points I've already made. So if I can say any more about that, that will be a new point, and I'll so to speak, a response, and I'll leave that for the reply. But I think the court is going to struggle on that pure causation point, because that's not the way the judge has approached the issue, and therefore the findings.
But why would the framing the law in a causation way I've described, i.e. analysing what would have happened but for the unconscionable delay, why would that be the wrong way of approaching it, and then seeing what effect that would have had on profits?
Well, I mean, it obviously has an attraction, because one is saying what is the effect of the unconscionable delay. A difficulty will be, but I accept this as a practical rather than a principal difficulty, is it's going to lead to something of a fact-specific inquiry in every case. But I've already accepted that sometimes you have to do that. So I acknowledge that doesn't meet my lord's point. Well, can I take that and cogitate a little more about it, if I may? And essentially the point, as I understand that my lord is putting to me, is, well, if there's going to be a principle here, we need to say to what has been the result, or what would have been the result if the claimant had not sat on his hands, but had actually started proceedings. Where would we now? Well, where would we have then been? Well, not where would we now be, but where would we have then been? My lord, I don't know if I've got. Have I got another point? My lord, I was just wondering whether I needed to say anything more about Lord Justice Jonathan Parker in Murad. I'm not sure I do at the moment. I'll check the transcript, and again, if I need to say any more about that, I have a very short opportunity to do so tomorrow. But unless the court has any further questions, those are our submissions on both grounds of appeal.
Thank you. Twice. We'll take a break now. Thank you.
All rise.
Yes, Mr. Vice.
My lord and my lady, I propose to take my submissions in 3 chapters. First, I will make some overarching submissions in relation to both appeals. Second, I will respond to the defendant's appeal. And third, I will open claimants. My lord, my lady, chapter 1, the overarching submissions. We say that it's important in this case to bear in mind what these appeals are not about. And given the way in which the defendant's written arguments, and to some extent their oral arguments, there's a danger, we would say, of losing some of the wood from the tree. And in that context, it's important to bear in mind that a number of the judge's findings, both as to fact and law, are unchallengeable and unchallenged. They provide the backdrop to both of these appeals, and it's important to have them in mind when assessing the merits of both appeals. And as to the findings of law, at the risk of stating the obvious to this court, I would, if I may, make 9 submissions based on the findings that the judge has made below, which are relevant for the purposes of assessing the case, particularly that the defendants seek to present. The first is that there is a fundamental rule that a fiduciary must not make an unauthorised profit out of their fiduciary position. That's judgment, paragraph 239C. Second, that rule is an inflexible one that must be applied inexorably. That's judgment, paragraph 251, citing Jonathan Parker, LJ, in Murad at 101. The third rule is that the basic equitable rule is a stringent one, which requires an errant fiduciary to account to his principal for all unauthorised profits falling within the scope of his fiduciary duty. That's judgment, paragraph 254, citing Gray in this court at 126. The fourth rule is that the rule, the basic equitable rule, is intended to have a deterrent effect and may lead to apparently harsh results. But those harsh results are the accepted price of the deterrent motivation which underpins the remedy. And that's judgment, paragraph 254 and 260. Citing Gray in the Court of Appeal at 126 and Regal Hastings and Borden and Phillips. The fifth finding that we rely on from the judge as to law is that if there's any doubt on which side of the line to stray, any doubt should be resolved in favour of the principal. And that's judgment, paragraph 260. Sixth, the deterrent effect is most clearly seen in the context of the equitable allowance. It cannot have the effect of encouraging fiduciaries in any way to put themselves in a position where their interests conflict with their duties as fiduciaries. That's judgment, paragraph 248, citing Lord Gough in Guinness and Saunders, and pausing there, I would submit that language is absolutist. There is a need for the equitable allowance not to be able to encourage. The word used by Lord Gough is cannot. And the third thing that I would derive from that principle is that it's necessary for the equitable allowance not to do it, quote, in any way. The seventh principle that we derive from the judge's judgment is that when identifying the profits for which a fiduciary must account, there's no requirement to show causation. The test is to show that there's a reasonable relationship between the breach of duty proved and the profits for which an account is ordered. That's judgment, paragraph 282. Now that principle is particularly apposite when one comes on to look at ground 2 of the defendant's submissions, because that, in essence, answers all the questions that the defendant seeks to raise. And that's how Warman is properly interpreted. See Lord Justice Parker in Murad. Indeed, the same approach is adopted to that particular decision by the New Zealand court in Churnside, and I'll show my lords and my lady that submission in a moment. The eighth principle is that the process of fashioning the account has to be done on the basis of established equitable principles. That's judgment paragraph 266 and paragraph 270. Now, regard must be had to all the facts of the case, such as the nature of the relationship, the facts of any alleged breach, and the potential applicability of any equitable defences, absolutely, but it is not a free-for-all. There's no wide-ranging general discretion, and both in relation to ground 2 of my learned friend submissions, and we say with respect the approach that the judge adopted towards setting the equitable allowance, that is what in fact occurred. The ninth principle is that the magnitude of the breach is not relevant, and there's no scope outside equitable defences to reflect any moral culpability on the part of the fiduciary. Judgment, paragraph 273. I will make submissions in a moment as to the alleged minor nature or the particular nature of the breach that my learned friend seeks to say is in play in this case. But we say that that is an important principle, particularly one takes it in connection with the principle that I outlined earlier as to principle 7, the need not to show causation, but to have a reasonable relationship between the breach. And we submit it is clear that the judge, having looked at the facts in detail, reached a clear and, we say, unassailable conclusion on those two important principles. The 10th point that I make to this court is one that is implicit in the judge's judgment, but it is not spelt out. And that is the Keach and Sandford principle, which is the fiduciary may be the only person in the world who's unable to pursue a particular business venture. And that's Keach and Sandford cited in IDC and Cooley at page 452. That's the Authorities Bundle 1, tab 10, page 265. And just to quote, this may seem hard that the trustee is the only person of all mankind who might not have the lease, but it's very proper that rule should be strictly pursued and not in the least relaxed. Now, my learned friend seeks to say that your lordship should and your ladyship should distinguish between cases where there is a particular bit of property, where there's been a hand in the till, or where there's a customer list. Those were the repeated mantras that my friend sought to articulate. And you should have those cases on one side, and you should have a business opportunity on another side, and I think on his case, even further at the extreme, is the mere, as he might put it, bad faith resignation. We say that principle approach is not borne out in the authorities. Moreover, as Warman makes clear, what Keach and Sandford is doing is partly talking about property, but partly talking about the position that the trustee occupies. And that is, in we submit, self-evident, because what equity is particularly concerned about is the position of the trustee, about the good faith of the trustee, the fact that the trustee is not in a position to be able to benefit from their position as trustee. The entirety of this appeal would, we submit, subvert those core principles. And we say the repeated references to hand in the till or to the customer list do not assist this court in working out what, in this case, this account should look like. Indeed, the judge's approach was entirely orthodox. She sought to establish what was the nature of the breach, what were the nature of the assets, and what nature or link or reasonable relationship existed between certain assets and the breach that she had found. So, my lords and my lady, we say that those 10 principles are useful guides when the court comes to assess how the particular fact of this case should be interpreted. I then come to the findings of fact that we say are overarching and relevant for the purposes of this appeal. And we would invite at this stage, and I'll need to look at the facts in due course when we come to the particular grounds of appeal and indeed the allowance, but at this stage, we say that there are 5 particular findings that the court should have well in mind. The first, and crucial in light of the way in which the submissions have been developed today, is that this was not a joint venture. Repeatedly, during the course of my learned friend's submissions, it was suggested that this was a joint venture between joint venturers, and in those circumstances the court should allow one joint venturer to have a particular share, either as a matter of right or as a matter of allowance, in respect of the fruits of the particular venture. That submission, we say, which runs throughout my learned friend's submissions, is entirely counter to the findings that the judge made. And if the court could take up the supplementary bundle 1, please, and turn to tab 18, one sees the way in which the judge approached, and my learned friend must accept, this particular
opportunity was identified and then exploited. And the starting point is tab 18, page 241, paragraph 371. And what one sees in paragraph 371 is a finding that the business opportunity was originally SCPI's and remained SCPI's. The bringing into being of the two claimants and their commencement of performing services did not mean that the opportunity ceased to be that of SCPI, in part because of the inchoate nature of the structure at the relevant times. At all points, SCPI could have directed the opportunity to another company. As Mr. Girolami put it in closing, the structure was subordinate to the will of the primary owner of the business opportunity. So equally, if negotiations were pursued for an agreement with, say, RP, at any time up to agreement of terms by both parties, SCPI could have directed the business opportunity elsewhere.
Sorry, which paragraph?
Yes, I've lost you.
Oh, I'm sorry, Lord, 370 little 1. Sorry, page 241. I'm
I
sorry.
was getting 300. Yeah.
I'm sorry.
No.
I'm sorry. I'm sorry.
I'm with you now.
Page 241, 370 little 1. And maybe the court could just read that paragraph to itself. And the final sentence is particularly important. In addition to the first sentence, the opportunity was that of SCPI until either took it, abandoned it, or redirected it. Then one goes to paragraph 371, this time for real, not 370 little 1. I apologise for that. It's page 242 over the page. And what one sees in between paragraphs 371 and 375 is that Mr. Rudhadze and Mr. Alexeyev were employed by SCPI. And we see that Mr. Marson was recruited and employed by Revoker. And perhaps the court could just read, if they could, paragraph 371 to paragraph 375. So what one sees from paragraph 371 is that Mr. Rudhadze gets access to the opportunity because of his position with SCPI. Paragraph 372, one sees that Mr. Alexeyev only gained the opportunity to be involved in the recovery services through his employment by SCPI. We see that Mr. Marson only obtained the opportunity to be involved as a result of his recruitment to be employed by Revoker. And one then sees in paragraph 375, for those, Mr. Rudhadze and Mr. Alexeyev, who were employed by SCPI, the opportunity came to them through that. And although Mr. Marson was not employed by SCPI, he came to it as a result of effectively being employed by the entities that were connected to SCPI. So the suggestion that this was a joint venture is, with respect, entirely unfounded. This is a classic case of fiduciaries working, employed for an entity, seeking then to walk away with a particular opportunity. Absolutely, the judge makes a finding that there is an unauthorised, bad faith resignation. But as the purpose of the account, what she then does is seek to work out what then arises from that particular breach. And unsurprisingly, she finds that within the scope of the account of profits are the profits that are obtained from this opportunity, which was provided to these employees in the course of their employment as fiduciaries by SCPI or by companies connected to And one sees the same differentiation between this sort of case and a joint venture case in the judgment in phase 2. And if the court could take up Call Bundle 1, tab 9, page 193, in the judgment, at paragraph 363, we see the court distinguishing, the judge distinguishing between a case such as this and a case involving a joint venture. And in that paragraph, the judge states the legal principle which we say is right and which we invite your lordship and your ladyship to uphold. But what she does, is she says, is where there is an antecedent agreement which limits the principal's interest. For example, in the case of a joint venture, the fiduciary need only account for profits in respect to the principal's interest, i.e., not this case. And similarly, at paragraph 422 of the judgment, at page 206, one sees the judge reaching the same type of conclusion. What she says is there's a threshold point. The principle as to antecedent agreements which I outlined above relates effectively to agreements which define the extent of the principal's interest. This is not such a case, because whatever the state of play as regards agreements to remuneration division of the spoils, they were or would have been agreements under the umbrella of SCPI or its successor. So SCPI had the business opportunity and was to contract with the family. 100% of the interest in the maturing business opportunity was that of SCPI. The principle as to antecedent agreements, therefore, is not engaged. So at the heart of Mullin and Friends' submissions to your lordship and your ladyship this morning, and then this afternoon, was that there's a joint venture here. That's not what the judge found. And we say the judge was right not to find it, and that finding of the judge is not under challenge. So that's the first factual point that I wanted to make. The second factual point that I wanted to make deals with what the judge did find was within scope, what the judge found was not within scope, and what the defendants got out of this particular transaction. What the judge found was that the work done on the recovery services, including the ESA in 2012, right up to the termination of the agreement in 2018, flowed from the original opportunity that the defendants had broken away to pursue. And as the court knows, that included over $94 million in cash and $80 million in assets. And the judge held that those assets fell within scope. What did she find was not within scope? She found that the RBS litigation was not in scope. That's 54 million. That's judgment paragraph 523. In addition, there were other assets which the claimants had originally claimed were within scope, but by the time of trial did not seek to say within scope, which were Liberty Bank, Cement Invest, and Magnicom. Very valuable assets, only acquired as a result of the defendants undertaking the recovery services, albeit insufficiently connected for the purposes of the taking of the account. Those were very valuable assets in themselves. Cement Invest had, for example, an agreed value of 24.9 million. So this is not a case of the entirety of the benefits, to put it loosely, acquired by the defendants as a result of their breach, or following on from, or in circumstances where they had breached their agreement, being subject to the account. A large chunk has been excluded, either as a result of the judge or as a result of the claimant's position. The third element in that is what fees did they obtain? And the court asked that question of my learned friend, and in the context of risk, it is important to see what, in fact, had been obtained. And if the court could turn, please, to, in the phase 2 judgment, to paragraph 193, one sees the answer. That's at page 157 of 1 tab 9. what one sees is responsive receipts. And in 193B, there was a central agreed call. Actually, sorry, start at 193A. They broke down into recovery and management fees, the RISA termination fee, loans, deed of termination, and related receipts and other. And what one sees is that the recovery and management fees were $29 million odd, and then the other figures are broken down as well. And what the court has in Core Bundle 2, tab 15, page 400, is Schedule B to the pleading put forward by the defendants, which breaks down those figures further. The court may wish to look at it or may just wish to take that note. And they show how those figures are broken down as between the various headings. So we submit, when one stands back, and I'll look at risk during the course of my submissions now tomorrow, we say that, yes, there was a risk, but the risk was, as was put to my learned friend, it was a risk of time, but that's always the case. But this is not a situation in which the defendants walk away with nothing. The defendants have very, very substantial sums of money, not brought within the account, but nonetheless, they have benefited hugely from their involvement with the family, their bad faith resignation, and their exploitation of these opportunities over a period of time.
Who are they? In the sense, but who ultimately shares in the almost 30 million of management fees? I don't, my friend, myself have a sense of the scale of the operation, whether they had employees or whether we're talking about a few individuals.
Look, those were all choices that they made. The choices that they made were how they would then receive management fees and what they would then do with those management fees thereafter.
I understand that, but there was a sort of, I wouldn't call it a jury point, but an appeal to look how much money they've got, and it's only a large amount of money if it's all in their pockets. It may not be a huge amount of money if they're running a large organisation in order to have to share it.
My Lord, I will be corrected. I will be corrected if I'm wrong, but I wasn't at the Phase 2 trial. But my understanding was that the defendants were unable to say how much they had individually received, save insofar as they looked in relation to management fees and other things. And what they looked at were, overall, these were the figures that had been received by them for the purposes of the account. I'm not able, on the basis of the materials I've seen, to be able to say, Mr. Rudhadze received X percentage of the management fees. But what I am able to say is, the defendants collectively received substantial sums over time. They could choose how best to use those monies as they wished. And in relation to those assets that were not included within the account, those were substantial assets not sufficient to be brought into account for the purposes of equity, but nonetheless, the RBS litigation, they would not have obtained but for having the relationship with the family, which they managed to obtain as a result of their bad faith resignation. If overnight I'm able to give more detail as to how the money, or where the money went, I'll do so, but my Lord.
Well, maybe the answer lies in the detail of the responsive expenses, but I haven't looked into that.
Mr. Cleaver helped from behind, so that is basically the point, and I'll come back to my Lord if I may in the morning as to exactly how one can see exactly where the money goes in terms of the particular. So that was the second point that I wanted to make. The third point that I wanted to make by way of factual finding is that the judge rejected the defendant's contention that this was a minor breach of fiduciary duty. And much of my learned friend's submissions this morning was in a way a rehash of that particular allegation. Not the hand in the till, not the customer list, not the business opportunity was, as I understood it, the submission that was being made, but just a mere bad faith resignation. Now, we submit that in the first trial, the judge made it clear that it was not a minor breach, and she similarly reached the same findings in the second round. I'll just give, if I may, the court some of the references. One starts in the second phase judgment, paragraphs 382 to 393. Actually, it probably is worth taking those up. So that's page 197. The original scope of the breach found. And this is relevant and becomes particularly relevant in circumstances where my Lord Wolfson seeks to suggest that this is a type of breach that is overall to be treated by this court as not so serious to bring the full panoply of equitable power. One sees in 382 the defendant submitted the objectionable act for the purpose of assessing sufficient connection with the disloyal acts and preparatory steps found in phase 1. Further alternative says if the breach touched upon any material business opportunity, that it was the MBO that was still being pursued by the claimant at the time of the breach, the door having been shut when any MBO actually provided the recovery services. But on this basis, it was said that the MBO was one to monetise Mr. Jaffe's claim, that he had a contract with the family, and that the MBO was not exploited by the claimant. And then 383 submitted that those breaches were minor. Then one looks at 384. The argument was premised on the consideration of the phase 1 judgment. The defendants contend to that, and then the court can see all the various contentions. But if one goes on to 385, the legal target of which the argument is shooting is essentially illusory. There's no basis for adjusting the accounts simply on the basis of characterising the breach as a small or minor breach. The closest the argument comes to gaining traction is in relation to the contention that these findings operate as a perimeter for a quasi-causal link. However, as I've noted, the authorities do not seem to support such an argument either. This is not a case of a discrete breach in relation to specific assets where such arguments do work. And we submit that those are clear findings by the judge, unchallenged on this appeal. Then this argument is also misconceived on the basis of the findings in the judgment. It involves reading down the judgment to a considerable degree. The first point is as to diversion. The simple point is this: I did not find that the breach of fiduciary duty was a diversion of business opportunity. I found breach of duty in the wrongful resignation. For the purpose of the phase 1 dispute, there was no necessary live issue as to whether the business opportunity was diverted. The focus was on whether a breach of fiduciary duty was established, and I could get there via diversion or by another route. And then did find a breach of fiduciary duty which related to the MBO, which I had found at 352 and 370. In many ways, the judge there is reading the diversion of the business opportunity as being a lesser part than the breach that she ended up finding. But in any event, it doesn't matter, because where it's not the diversion of a discrete or a specific asset, then her findings then have application. Then 387, the business opportunity was not really an issue. It was the opportunity to provide the recovery services to the family for a substantial fee. No issues to what that comprised. I did find the business opportunity was that of SCPI, and also found that it was a live business opportunity. Then she sets out at paragraph 388 her findings from paragraph 384, and I don't think I need to read that to the court. But then 389, at the next stage, there was no issue that Honeywell and the defendants ultimately performed the services which the MBO comprised, and then she finds, in that sense, therefore, there was a diversion. Further, she says, I did not simply find that there were certain preparatory steps, and she sets out the key passage in the judgment at paragraph 424. And similarly, in paragraph 391 and 392, she makes further findings. And I invite the court to note those, and look then at paragraph 393. At that stage, the judge was saying that Mr. Cogley was making ingenious attempts to take the act of preparation away from any chance of a deal with SCPI, we would say, with all respect to my learned friend, he's making similar ingenious attempts to try and separate out the nature of the breach here from the account that comes to be given. And we say, for the same reasons that the judge found in relation to the submissions made by Mr. Cogley, it's a very partial and incomplete view of the facts. It may not be possible to conclude on the balance of probabilities that defendants actually positively caused the family to terminate the relationship with SCPI. The deal which SCPI had sought may have been over, as Mr. Jaffe effectively agreed in his evidence in this phase, before the date when the resignations took place. He had been facing the prospect of monetising the opportunity or settling for a very different deal. However, the defendants essentially encouraged and colluded in the family's disenchantment with SCPI, the more so in that they allowed the family to know that they were an alternative. That was part and parcel of the disloyalty which I found. In those circumstances, and in light of those findings, the suggestion that this account should in some way allow an antecedent agreement to survive, or indeed we would submit, allow delay, whether it's unconscionable or not, to prevent the recovery of the remedy, would we say be an outrage from the perspective of normal orthodox equitable principles. What is in effect being said there is that these defendants prevented SCPI from being able to exploit the particular opportunity. And by that stage, Mr. Jaffe may have been facing the prospect of monetising the opportunity or settling for a very different deal. The suggestion then that Mr. Jaffe should be prevented from suing in circumstances where over a very prolonged period of time, these proceedings having been commenced in 2016, should be prevented on some complicated percentage formula from having the account that equity would otherwise give him, not him, actually, SCPI, would we say, run contrary to orthodox equitable principles. So we say it's vital when the court comes to look at the submissions that are made by the defendants to have well in mind the nature of the breach that the court found below. Similarly, one can see findings by the judge in the first phase which undermine the approach that my learned friend seeks to adopt. And if I can just give the court the references in the first phase judgment. Paragraph 84 of the first phase judgment is important. Maybe, actually, it's probably better to look at it in real life. If one could go to the supplemental bundle 1, tab 18, paragraph 84, that's page 179. The judge says it's quite possible that a bad faith resignation in breach of fiduciary duty may exist unaccompanied by any preparatory steps which qualify as separate breaches. That seems in the abstract to be consistent with the approach of regarding business opportunities as the property of the company, so that a resignation specifically to exploit such an opportunity can be seen both as a breach of duty of loyalty and as a breach of the no profits rule. In Midland Tools, it's noteworthy that evidence of specific business opportunities was lacking. However, I do not consider that the authorities to date justify a firm conclusion that a resignation with an intention to compete is necessarily by itself a breach. Further, it would be a rare case where there is literally nothing more to assist in discerning which side of the line a particular case falls. Now that's relevant when one comes to look at overall the approach that my learned friend seeks to adopt. There are two other matters that answer some of the complaints or the submissions made by my learned friend in relation to facts. The first is that he said there was nothing clandestine about what was done by these defendants in this situation. I don't suggest that, I'm not going to show the court those paragraphs now, but if the court could go and look these at paragraphs 290, paragraph 418, and paragraph 423 of the first instance judgment, one sees clandestine acts consistent with, in itself, a breach of a trustee's duty. Obviously, the court didn't need to make findings that there was a clandestine breach. It's sufficient that these trustees, these fiduciaries, abused their position in the way that they did.
So you said those are in the first
In
instance.
the first instance judgment. Yes, my lord.
First phase judgment.
First phase judgment.
First phase.
The second element that I would show the court, if I may, is, again in the first phase judgment, is evidence that go, or findings that go in relation to my learned friend's point as to whether or not this was an agreement that might still have, the antecedent agreement might have still subsisted. And he proceeded with his submissions on the basis that these weren't employees. I've shown that that's wrong. But one also sees how these particular defendants dealt with themselves and how the parties then dealt with themselves. And one can pick that up, please, in paragraph 292 of the first phase judgment. That's in Supplemental Bundle 1, tab 18, at page 226. And when one sees paragraph 292 to 298, one sees that the suggestion that there was some subsisting contract between these parties simply cannot stand the scrutiny at all. And if,
did you say 292 to 298?
yes, I did, my lady. And perhaps the court could just read those paragraphs now. So what we would submit, particularly when one looks at 297 and 298, is the suggestion that there's some agreement that continues to subsist as between Mr. Jaffe and Mr. Rudhadze simply cannot stand the light of day. Mr. Marson purported to accept what he described as a revoker's conduct as a repudiatory breach, and Mr. Rudhadze and Mr. Alexeyev resigned as members of Revoker, citing the manipulation of the LLP for his own ends, the illegitimacy of their suspension and their exclusion from the management of Revoker. So the idea that there is some other agreement, apparently not between SCPI and Mr. Rudhadze, but between Mr. Jaffe and Mr. Rudhadze, which survives, is, we submit, nonsense. And that is the contract for which my learned friend now seeks to contend. When asked by my lady as to who the parties were, his answer was Mr. Jaffe and Mr. Rudhadze. But of course, SCPI had the business opportunity to exploit. SCPI was the employer of Mr. Alexeyev and Mr. Rudhadze. SCPI is the company by way of assignment that pursues these claims. In fact, the claimants pursue it as assignees of SCPI, one of them does. So the suggestion that SCPI has in some way been bound by an agreement between Mr. Rudhadze and Mr. Jaffe as to the antecedent share simply doesn't stand up when one looks at the underlying factual findings that the judge has made. And the suggestion that the contract continued to subsist is, we say, not one that should trouble this court. The fourth point that I want to make very briefly is that the judge found that the defendant's wide-ranging attack on Mr. Jaffe was at the very heart of the defendant's case. That's judgment page 331, but was in fact a complete sideshow. To some extent, the arguments that the court has heard, both in relation to antecedent agreement and in relation to unconscionable delay, are a rehash of some of those arguments in a different form. but they continue to focus on the position of Mr. Jaffe at the expense of properly analysing who had the opportunity, who would need to have entered into an agreement so as to prevent an account of profits being pursued in respect of the entirety of the profits that these defendants, in fact, came to earn. And the fifth and final point, by way of facts, is that the judge rejected the defendant's claim that they were entitled to an equitable allowance by way of their unique skill, their exceptional skill, or the risks that they ran. And that's judgment, paragraphs 438 to 453. And that claim, as to a unique and exceptional skill, was one of the main limbs that lay at the heart of their case before the judge. We say understandably using the language of exceptionality, because that is the very language that high authority tells us needs to be satisfied in order for an equitable allowance to be given. So that, the unique and exceptional skill rejected by the judge, to some extent half-heartedly resurrected by my learned friend during the course of his submissions this morning, by saying that this was a risky venture. And I'll come to look at the precise citations in relation to risk during the course of my submissions tomorrow. So those are the overarching legal and factual positions that we say inform both types of appeal before this court. I don't know whether the court is going to sit to 4:30, whether we want to break at 4:15.
I was going to break at 4:15, but I'd rather you went a bit beyond than a bit short.
Very good. Then
Could I ask you one thing before you move on?
Certainly.
Mr. Lord Wolfson submitted quite frequently during his submissions that emphasised this wasn't a case of diversion. It was just as he put it, a disloyal resignation. As I understand it, what we're actually talking about are preparatory acts and then a resignation in order to compete. Do you accept that there's anything less wrongful or in any way substantially different between preparatory acts and a resignation and actually diverting the contract whilst employed?
I don't say that there's any material difference for the purposes of fashioning the account, and that's the position that we're actually in. And moral culpability is in itself not a relevant factor. What is relevant is what is the reasonable relationship between the profits that have been incurred and the breach of fiduciary duty. And what the court will say when fashioning the account is to say, well, what was the breach and what were the assets that were then obtained? And by drawing the line between some assets that are reasonably related to the breach and some assets that are not, the court will take a view. But it's not a view based on culpability. It's a view based on the nature of the breach and the connection to the asset.
Thank you.
So, subject to the court, I would then turn to Chapter 2, my Chapter 2, which is the defendant's appeal. And what I propose to do is take them in the same order as my learned friend, and perhaps unimaginatively, I'll deal with ground 1 first, and then with ground 2. With ground 1, I propose to take my submissions in the same order broadly as we've taken them in our skeleton argument. So I'll deal with the factual background, then I'll deal with the legal background, and then I'll make my submissions. So first, the factual background. We've set that out in some detail in paragraph 9 of our skeleton argument, and I don't intend to repeat it, but I do want to show the court, if I may, some of the underlying materials. The first piece of underlying material that I want to show the court is the defence, put forward repeatedly by these defendants in the context of the first phase trial, but not resolved upon by way of statement of truth for these phase 2. And that's in Supplemental Bundle 1, tab 15. It starts at page 90. And I'm interested in paragraphs 3.6 to 3.8, which appear at pages 91 and 92. And just before one comes to those, one sees at page 90 that it is the re-amended defence. So repeated opportunities to the defendants to state what they said the case to be. And paragraph 3.6, the Salford principles, began to provide the recovery services in the absence of any agreement with the family or between themselves, and did so in the hope that such agreements could be concluded in due course. The services were therefore provided by the Salford principles on an ad hoc basis, and also paid for on an ad hoc basis as and when the family's finances permitted. The services provided on such a basis are hereafter referred to as the interim recovery services. And my lady asked my learned friend about what happened between 2008 and 2011. The description given by the defendants at this stage was that they were called the interim recovery services.
So this is pre-2011, obviously.
Yes, my lady.
Okay, it also suggests there was some payment.
Yes, my lady. And there were management fees paid. And one of the issues in the phase 1 trial was what was the significance of those payments. Those payments were paid at the instigation of SCPI, not paid individually to these, as they call them, the Salford principles.
Sorry, you're saying they were paid to
SCPI, yes, as one would expect. Then paragraph 3.7, it's further denied if alleged that Mr. Jaffe and the family agreed that the provision of the recovery services would be formalised and given contractual effect by way of a contract between the family and SCPI and all the claimants. Between 2008 and 2011, the Salford principles attempted to negotiate an agreement between themselves as to how the proceeds of the recovery services would be divided between them. And then an agreement with the family. But we rely particularly on that passage. And then paragraph 3.8, in the event both sets of negotiations were unsuccessful, the commercial terms of the negotiation between the Salford principles were never concluded. Now, repeated statements of truth attached by Mr. Marson to those statements, and then later Mr. Hughes, who signed on behalf of some of the other defendants. And one sees a succession of counsel settling this particular document. Mr. Adkin QC first with Mr. Casey, then Mr. Girolami QC with Mr. Casey and Mr. Pringle. Mr. Pringle, who sits behind my learned friends today. No explanation has ever been given, proper explanation, as to how those pleas came to be made and how those pleas now seek to be departed from. But at the very core of ground 1 is a suggestion that the court can throw out those paragraphs entirely and find that there was an antecedent agreement between Mr. Jaffe and Mr. Rudhadze, which binds by implication SCPI, and which this court, as a court of equity, now needs to give respect to. That's the first document that I wanted to show my lords and my lady. The second is the phase 1 judgment. And if I could pick that up, and then, my lord, that may well then be a convenient moment to stop. Yes. That's in tab 18. It starts at page 156, and if I could pick it up, please, at paragraph 170, which is at page 198. So this picks up the story in early October 2008. At paragraph 170 on page 198, Mr. Rudhadze says at the same time an agreement was made between himself and Mr. Jaffe and Mr. Blumpkin. So at that stage, the agreement was said not just to be between himself and Mr. Jaffe, but also with Mr. Blumpkin, that any corporate structure used to provide the recovery services would be owned by them in proportion to their agreed shares in the profits.
I'm so sorry,
I'm sorry,
where
mate.
you are. Where are we?
It's page 198 in tab 18.
Paragraph.
170.
Oh, in the phase 1 judgment.
In phase 1 judgment. I'm sorry, my lord.
No, it's my fault. Right, I've got a note, you're gone.
That is the allegation. And then, since by this stage it was clear that Mr. Rudhadze would be leading the project, it was also agreed that Mr. Rudhadze would have the largest single share of 40%. So that's the case that Mr. Rudhadze is seeking to put forward. And paragraph 171, the claimants submit that this contention cannot stand. They point out that prior to the hearing, it was not clear how the defendant said that this agreement, to move between an SCPI opportunity and a confederation of principals, and as to the split of the shareholding, was concluded. They point to the fact that the pleaded case appears to be incompatible, and then the judge sets out paragraph 3.6, which I've already shown the court. They flag up the fact that no document was identified, no oral agreement alleged formally. At best, they submit, Mr. Rudhadze suggests in his witness statement that an agreement was reached between Mr. Jaffe, Mr. Blumkin and Mr. Rudhadze that because the family had said they didn't want Mr. Jaffe to control things, it was agreed to approach the recovery services as individuals. Then at paragraph 172, the claimant's position was as follows, and invite the court to read those paragraphs and then note paragraph 173. So at 173, there is then the finding. I conclude there was no such agreement as this alleged by Mr. Rudhadze. And then she sets out at 174 to 181 further reasons as to why that should not be the case. And I don't think at this stage I need to show the court those paragraphs, but they support that underlying finding. Moreover, during the course of the Phase 1 trial, the court considered the type of spreadsheets that I'll need to make further submissions to the court during the course of tomorrow. But while we're in the Phase 1 judgment, it's sensible to turn back, please, to page 187 and to look at paragraphs 121 and 122. And what one sees is that Mr. Rudhadze said that even at that stage, he saw himself as the next most important person in SCPI after Mr. Jaffe. So pausing there, even at that stage, he wasn't saying that he was a joint venture. He was simply saying that he was subordinate, but first amongst the other subordinates. I have no difficulty in believing this evidence. However, in broader terms, he was seen within SCPI as only one of the most important people. And then a presentation from around this time indicates that he took rank officially as equal to other managing directors, Mr. Ashurov and Mr. Petrovich. While Mr. Jaffe certainly had great confidence in him and regarding him as a likely heir if he ever stepped back from SCPI, Messrs. Blumkin and Nagel took at least equal rank operationally. And then paragraph 122.
What is at this time?
So at this time, this is still in 2000, and this is between, I think, 2005 and 2008. Or certainly it's before it's before Mr. Patakashvili's death. One sees that from 1 to.
But I was more interested in how long before it was or might have been the agreement which is relied on being reached, which might be more relevant.
What I'm really relying on though is what then comes in 122.
Right.
Because what 122 does, it sets up what happens in relation to the allocation of entitlements. Entitlements being the word that was used by the parties, but not ultimately a word that means an entitlement that is absolute and undeniable. So this hierarchy is reflecting the fact that none of the Salford managers, apart from Mr. Jaffe, held an equity interest in SCPI. Instead, they and Mr. Rudhadze was in this respect no different to Mr. Ashurov and Mr. Petrovich, were given percentage shares in SCPI's entitlement to carried interest arising from the sale of managed assets. These amounted in early 2008 to a very large sum, estimated by Mr. Jaffe as about $300 million. Mr. Petrovich's unchallenged evidence was that Mr. Jaffe was the person who made decisions as to the amount of the economic interest, which each, quote, partner should have, and this was reflected tellingly in a series of Excel spreadsheets, which noted shares in various assets, including the recovery services, at different times, with amendments noted as EJ approved. And we'll come to look tomorrow at the way in which the judge deals with spreadsheets for the purposes of the Phase 2 judgment. We'll also look at the way in which Mr. Jaffe and Revoker dealt with the spreadsheets in the purposes of their proceedings against Mr. Nagel, Mr. Blumkin, Mr. Khan and Ms. Gabbard, in the circumstances where they wanted to make clear whether those 4 individuals had entitlement, ultimately, to the proceeds of these proceedings.
I gather that there's been an email from a journalist who's following the proceedings remotely, who wants access and has not been given access to the skeleton arguments. I would have thought that they ought to be provided. Will there be any objection to that?
My side. My Lord, no objection.
No. Well, can we leave it for the parties to arrange that then?
My Lord, yes.
Thank you. And am I right in understanding that you're going to arrange for us to have a transcript as soon as it's available?
Yes.
Thank you. 10:30.